before you hear from Professor McQuilkin, can I eat into my remaining time by dealing with 3 short points?
Right.
First, housekeeping. I've handed up the form of words that I read out about the implementation of the award. We've also handed round copies of Eclairs, and can I suggest that that becomes tab 12
Yes.
of the blue bundle?
But I've actually put the UN resolution in as tab 12.
I'm sorry.
Because that didn't seem to be in the index, and
Your
it seemed to me the
quite
UN
right.
resolution was really rather important. So can we make Eclairs 13?
Yes, thank you.
Yes.
Second point, I had intended but forgot to give you the bundle references to the 1965 undertakings and their publication in Mauritius. They're set out conveniently in the arbitration award, so it's bundle 4, and the paragraphs of the arbitration award, I won't take you to now, are 77.
77.
Yes, 83 to 85 and 102, and the memory stick page numbers are 1277 to 1283.
Thank you.
And 1290.
Thank you.
Finally, can I just make one short point on the Vienna Convention? Even if the court does not accept the full width of my submissions about interstate communications, the convention does apply in full to however many copies there are of intra-state communications, which is what we are dealing with. So that's communications passing from the sending government to its mission in the receiving state and vice versa.
Yes. Right. Thank you very much indeed. So we now hear from Professor McQuilkin.
My lords, my ladies, my submissions are entirely in relation to the admissibility of the cable and in relation to the Vienna Convention on Diplomatic Relations. However, before I do that, there are a few matters of international law that came up during the course of the other arguments, which perhaps I can helpfully clarify. The court asked about what the position was in relation to the legal obligations arising from the Chagos arbitration between Mauritius and the United Kingdom. The situation, as I'm sure you're aware, is a decision of an international tribunal, which the United Kingdom has accepted the jurisdiction, has submitted to the jurisdiction, and has argued before the jurisdiction, is a decision which is binding on the United Kingdom at international law. It is not binding on the United Kingdom in most instances at domestic law. However, the courts of the United Kingdom have considered these international decisions as a persuasive guidance. I will just give one example, which I don't intend to hand up, but it's a fairly familiar one, the case of A and the Secretary of State for the Home Department in 2005, UK House of Lords 71, where they were considering the issue of the prohibition on torture, and in doing that, the House of Lords looked at a range of different international decisions in this area. The second point to make, which is one which I think...
well, that's on law, isn't it?
It's on the, not on the facts, that's correct, it's on the law. So, for example, it looked in that case at what the Human Rights Committee had said, what the International Criminal Tribunal for the former Yugoslavia had said, and so it was persuasive in that regard.
We do that all the time on the law, but I suppose the relevance here of the award is more on the factual findings, and they are factual findings, aren't they, that there were fishing rights and that there were, well, I suppose they're mixed fact and law, that there were fishing rights in international law and that there wasn't proper consultation.
I'm not quite sure I would agree with you, Lord Mance. The decision by the arbitration was that the Lancaster undertakings were binding at international law, and that is an international law decision. It's not a fact.
Whether they were made in the terms alleged, and whether an understanding had been allowed to subsist to that effect during the following 3 decades. And those were findings of fact. They had legal consequences, but they were actually findings of fact.
Correct, but of course the finding of law was that those understandings were binding on the United Kingdom.
Well, I think if they were sufficiently clear, it wasn't disputed that they would be binding. The argument was they weren't.
Maybe I can clarify that by if we actually look at the decision, and the respondent has already taken you to the...
I'm not sure this case actually depends on it.
I'm not sure we necessarily get very far on this.
Especially as it's not being argued that there were binding fishing rights. I mean, that's the oddity about this case. The permission is given on one basis, which has not been resolved from permission to
except
raise
that
the fishing issues point.
Except, of course, the appellant does argue that the fishing rights is a separate argument to that of sovereignty. Our whole argument on ground 1A is about the new evidence shows they were separate issues.
Well, I know that's the difficulty, but the way it's formally put is consistent with the original permission, and all that is said is that there were arguable rights in international law of fishing. Yeah. So it's quite difficult to know how to fit the award into that, since the award says that there were in international law rights.
Yes, indeed. Perhaps I'll leave that to your contemplation. But if I can follow up on that to say that the United Kingdom has tended to, almost without exception, comply with decisions even made in international arbitration where their decision has gone against them. I can give you not only, of course, the Alabama claims case, but more recently the Eurotunnel case, in which it was quite clear in the end the United Kingdom with France had to pay 24 million euros. They did not like the decision, but they complied with it. And the reason I make that point is that actually in this instance, that's not what I think is being done or being asked by the arbitration for the United Kingdom to do. If I can just briefly turn to, in fact, it's already been mentioned by the respondent, so I just need to make the point, which is that the declaration by the tribunal was that in establishing the MPA surrounding the Chagos Archipelago, United Kingdom breached its obligations under various articles of the UNCLOS. So here we have a clear statement, there was a breach. Now, the remedy of that breach is, of course, is to not only to have consultation negotiations, which the tribunal says, but the current MPA is unlawful. That has to be the only conclusion one can draw from this. So for the government, as we hear in the very latest statement, to say, we are not changing the MPA, has to be an act contrary to the decision of the tribunal. So if we would like the United Kingdom to be acting according to an international rule of law, then we would have to say that current statement is contrary to it.
Is it automatic in international law that if there's been a breach of a duty to consult, the whole measure is axiomatically unlawful? Is there no discretion as to the remedy? Could not the ICJ or International Tribunal be satisfied that it was sufficient if there was consultation now?
It could be, but that's not what the tribunal says. The tribunal has two parts. One is there should be negotiation. The other is this clear statement that the MPA, in its current terms, is unlawful.
Yes, but you've got to ask yourself in what respect. If the unlawfulness can be corrected by something short of not having an MPA at all, then they would put themselves into a state of lawfulness by doing that. And the problem about this area is that there's no absolute standard of access for fishing vessels. It may well be that a complete blanket ban on any fishing would not be consistent with it, but it's not inconsistent with having a licensing regime. The licensing regime may be more or less generous, so that the question what has to be done to make the United Kingdom's conduct lawful in accordance with the award is not at all straightforward.
I completely accept that, Lord Sumption, but it doesn't take away from that the current MPA is unlawful.
Well, you have read, no doubt, the statement on the implementation of the arbitral award. And the assertion is there made that the award did not require the termination of the MPA.
That's the assertion by the UK government. That's not how I would read.
Well, perhaps you're going to take us to the terms of the award, which you say do require its termination.
Well, you're quite right. It doesn't say it has to be terminated. What it said, which I read to you, of course, was that in establishing the MPA, the United Kingdom breached its obligations. So that has to, I would argue, follow that therefore the current MPA is contrary to United Kingdom international obligations.
It's not what we've held in other contexts. I mean, we've held that in detaining someone in prison, for example, without giving them a reasonable opportunity by courses to demonstrate their fitness for release, the UK may have been or has been in breach, but it doesn't mean that the imprisonment itself is in breach. And I think in establishing the MPA, breached its obligations, is capable perhaps of that. So I think it would be helpful, that sort of interpretation, be helpful to look a bit more deeply at.
Maybe I can answer it this way. The kind of example that you've just given, Lord Mance, is of course one where the state has a range of options it could choose to do as to how to comply with a breach of an international obligation. That is the standard position under international law. Even, for example, in a human rights case, a decision by the European Court of Human Rights, the state has a variety of options as to how it wishes to comply. And I guess that's where you're taking me, Lord Kerr, is here it may not mean termination. I accept that, but it doesn't mean that that's also not an option. But it clearly means the current MPA is unlawful.
But can it be brought into a condition of lawfulness by undertaking the consultation which the statement contemplates?
Yes, that of course would be absolutely one way of doing it. Another way might be to actually terminate the existing one or to amend the existing one so it takes into account the decision of the arbitral tribunal, neither of which we understand the government is intending to do at this time. Perhaps if I could move from that to the main aspect of this part of the case, which is of course the admissibility of the cable. Now, our submission is substantially that the respondent misunderstands the position, and we say that in three ways. Firstly, the Vienna Convention on Diplomatic Relations does not apply at all to this situation. It can only apply if the United Kingdom is the receiving state under that treaty, and as the cable was a document of the US government sent elsewhere, it was not a document of a sending state, the US, and therefore the convention doesn't apply. Our second argument is if it does apply, then we need to work out what do we mean by the word inviolable. And to do so, the court would normally apply the principles of treaty interpretation, which it has applied throughout many, many cases. And in our view, that would not lead to the conclusion that the definition is inadmissible. But as we will show, it would mean that it cannot be forcibly interfered with. The third argument is none of the respondents' submissions, they have 7 kind of scattergun submissions, establish that a diplomatic document of the United States that was copied outside the United Kingdom, that has been in the public domain, including in the United Kingdom, for a substantial period of time, is not permitted ever to be admissible as evidence in any kind of court in any country.
Is that a submission, that last one, about what constitutes an archive or the archive?
It does, and I'll come to that when I expand on this point, in terms of the very questions that you are asking, how far does it go as to what is an archive? Because the way I start from that is that the core principle of international law is territoriality, that a state's obligations and jurisdictions generally only go to the extent of its territory. It could not go to a document somewhere else in the world and have obligations in that regard. And particularly in this instance where the United Kingdom itself, the government has no control over it, and certainly the appellant had no control over it. So from that, we would then come to the overall submission that the Court of Appeal, led by the Master of the Rolls after considered opinion, their decision has to be upheld that the cable is admissible. Now, before I get to the submission, I just need to make one other comment on the respondent's case, because it's changed considerably between the written case, the speaking case, and the presentations. And if I can perhaps just clarify that. In the written case, at paragraph 57, there's a very clear statement that inviolability is an absolute principle and can never be undermined or changed or affected. But actually, that was not what we either see in the speaking notes or in the presentation. In fact, it became clear there are some circumstances. In the written speaking notes, it talks about national security. In the submission, we talked about eaten by the dog. There seem to be a range of different other possibilities. The second thing is there is an acceptance in the speaking notes that we do need a definition of inviolable. There's also a concession in paragraph 15 of the speaking notes that articles 24 and 27 are not customary international law. There's also seems to be acknowledgement in the speaking note of paragraph 10 that there was an actual cable produced by the US mission in London, a copy of which is subject to this case. And we haven't actually got that far before, which perhaps deals with...
Well, whether it's customary international law,
Oh,
if it's a treaty of substantially universal adoption.
I don't think it matters that much on the broader position. I think it does actually matter.
At all.
Well, I think it does, because in the written submission, the argument was it applies to every state who is a party to the convention.
Well, that's every state, with the exception of 4 tiny states.
But these articles do not apply to every state in relationship to another state. If, for example, the US and Cuba do
They
not
apply
have
as between sender and receiving state.
only, and that I agree with, and I think that does make a difference, as I hope to show. But also maybe picking up a point which Lord Reid made, it does seem to be that there is, on the basis of the case which the respondent took us to, the UNRO case, some acceptance that there is an actual document held by the US state which is the same as the document of the copy cable. I'm not going to go through that at the moment, but if we have a look at, when you have a moment, have a look at the pages 3104 and 3111. That seems to indicate that there is actually held in the US State Department a copy of this actual cable. And one other point I wish to make, maybe just as a clarification, it came up in questioning, that who wrote the chapter in Sato? That is written by Eileen Denzer,
Well, I rather thought
and
so.
has been written by Eileen Denzer across almost all its editions until the very most recent one, where it's jointly written with Joanne Folkes, who is a long-standing, just former member of the FCO, and it hasn't substantially
A
changed.
replication of her book.
Exactly. So they aren't two separate commentators in that regard. So having set all that scene, if I can, why do I start with my first submission? For all this discussion, the Vienna Convention on Diplomatic Relations simply does not apply. Well, the first one is, and it picks up something which Lord Sumption has hinted at, the Convention is a series of reciprocal obligations between sender and receiver. It is not exactly the same obligation for every state in every instance, and I'll explain that in a moment. And secondly, the United Kingdom is not a receiving state in this instance, and therefore the Convention cannot apply to it. So let me just take the first part. If, as I say, the Convention creates a coherent system of obligations, which are about obligations between a sending and a receiving state, within a multilateral treaty, very common in many instances, then we talk about reciprocal legal obligations, but you need a sending state and a receiving state. And the respondent in his case relies heavily on a decision of the International Court of Justice in the US consular relations in Tehran case. And in that, he relies in his written document that this is a matter of general customary international applying to all states. But as I've said, he's now resolved from that position to accept that the Convention applies as between sending state and receiving state. Why does that matter? Well, if we can turn to that case, and we'll find it on page 3188, which is volume 8, page 3188.
Okay. Yep.
What I wish to do is read pretty much the same two paragraphs that he read, but maybe showing a different emphasis on it.
Not necessarily read them, but
No, please, just read for me paragraph 61 and paragraph 62. The key word in both is the term a receiving state.
Is the argument that that so far as the state, through its judicial branch, permits reliance on a document, it isn't acting as a receiving state? Is that the point? Because we clearly were the receiving state vis-à-vis the US Embassy in London.
Exactly. It has the situation of receiving and sending state has to occur in relation to this document, and I argue that it doesn't.
Precisely.
There clearly is a US mission in the UK. There clearly is the UK in that broader sense is the receiving, but not for this specific purpose.
Does that mean that if a foreign power arranged to rob a London embassy, not its own, it wouldn't be infringing the Vienna Convention on Diplomatic Relations?
The foreign state would not. The United Kingdom might be.
Wouldn't it be infringing the principle in Article 24, which the archives and documents of the mission shall be inviolable? Why do you restrict every article to the relationship between sending and receiving states? Sometimes it refers to receiving state, but one might have thought that that was a general obligation on all states parties to the convention.
Well, with respect, I don't think that's what the convention takes us to, and what the International Court of Justice similarly does.
Well, there are separate provisions up there in relation to third-party states.
Indeed.
Involving transit of diplomatic agents through third parties.
That, in a sense, proves the issue that otherwise, if it's a different state, then different obligations arise. But in your example, if a third state came in and stole the documents, then that state itself doesn't breach the Vienna Convention. It might well be the United Kingdom did if it didn't allow appropriate security, but that other state does not do that. And that's clear from the International Court of Justice, which says these are obligations only of a receiving state.
Where does it say that?
Article 61, paragraph 61 rather, it says, by a number of provisions of the Vienna Convention, 1960, for Convention 61 and 63, as a receiving, Iran was placed under the most categorical obligations as a receiving state.
Yes, but that's just the facts of that case. And I'm sure it's referred to specific paragraphs which refer to the receiving state. It doesn't mean to say that all the articles are so confined. It may not matter, but...
I think the articles in question, Articles 24 and 27, have to be so constrained. Otherwise it would not make sense, because let's take a different example. In international practice, there are states which are party to the convention but don't have diplomatic relations with each other. The United Kingdom and Bhutan aren't in diplomatic relations. The US and North Korea do not have diplomatic relations. They are all parties to this convention, but they cannot have these type of obligations because they are not sending and receiving states. They don't have diplomatic missions.
Well, interestingly, quite a number of the articles which precede Article 24 and which succeed it do refer to the receiving state. Some articles refer to the sending state, but Article 24 itself doesn't refer to the receiving state.
Of course, that's right. But if we look at the definition in Article 1 of what a mission is, it is, of course, a mission in the receiving state, mission of the sending state.
Yes.
Thanks.
Is it?
It says, the head of the mission is a person charged by the sending state with the duty of acting in that capacity, and therefore it all follows from the rest of it, where the mission is, that it has to be linked to the sending state.
There's no doubt about that. I mean, a mission is by definition something which you send.
So my point is, that these provisions simply cannot apply to every state no matter what, because if they don't have diplomatic missions, then it's not applicable. So in our view, if we can show the United Kingdom is not a receiving state for this purpose, the convention simply does not apply. And the starting point for that is whether on the facts that is the case. And you're very familiar with this, you can turn to it if you wish, but the Divisional Court said at paragraph 30, which is on page 361, adopted by the Court of Appeal in paragraph 17 of its decision, it said this: "It has not been suggested that it is likely that the document, which is of course the cable, was obtained from a storage facility at the US Embassy in London. In light of these considerations, we are prepared to assume that the document was obtained illicitly by a person who is not authorised to obtain it from a US electronic document for storage facility elsewhere than in the US Embassy in London." as Lord Sumption has already indicated, it's probably most likely it was obtained by Chelsea Manning from a US military facility in Iraq. After it was sent there, not from the US mission in London, but from the US Department, probably the Department of either State or Defence in the US. It was clearly not, and we can tell that because if you're able to turn to the
Yes.
the
Tab 5.
actually no, tab 2, which is of the new documents, which is the
yes,
actual
of course.
cable from the Telegraph.
Yes, of course. Yes.
We can see, and I think you've already been taken to this, the word, the header, which isn't actually the headline, says
Yes.
who it was sent to. And I'm not great at understanding what each of these various terms are, but it's Port Louis is, of course, in Mauritius. It says Diego Garcia. It does not say Iraq. So this document was not sent to the US mission in Iraq, where it probably came from. The only point I want to make from that is to say that that any document which was copied or otherwise taken elsewhere than that, it was clearly no longer a document of the mission. And I would argue that the UK cannot have international obligations for a US cable held in Iraq or anywhere outside the UK's territory. To do that would be an extraordinary step in international law. To hold a state responsible for a document sent by another state elsewhere in the world and for which it had obligations in relation to it. And such an obligation, I think, is beyond what we could even consider would be in the implication of the convention.
Well, and the only obligation suggested is to deal or not to deal with it in a particular way in your own jurisdiction.
I
It's not
completely
suggesting
agree.
we have to send an armed force to rescue it in Iraq or from Chelsea Manning or whatever.
And to take that further, it also doesn't suggest that somehow or other, if the document then comes back into your jurisdiction, that it is the same document which was actually in the archive. It is now a different document. It may be a copy of it, but as discussed when there were various questions from the court to the respondent, the document is no longer the same document if it is being copied and sent elsewhere. It is now no longer a document of the mission.
I mean, Article 40 sub 3, going back to the point you made about sending and receiving states, appears to contain the obligations in relation to documents of a third country state.
Yes, but of course Article 40 subsection 3 is only in relation to transit.
Yes, I know, but that seems to be the limit of the obligation imposed on third states who are neither sending nor receiving.
But only if they're a third state in transit, because I would read that this is about...
Yeah, absolutely, but in relation to this, third states are states that are neither sending or receiving. On the face of it, Article 40 sub 3 is imposing that obligation because it doesn't arise from the provisions relating to documents earlier in the Convention, which is why you have special provisions indicating the limits of what they are required to do or refrain from doing.
I accept that. So I can just maybe lead us to this by perhaps an example. The United States withdraws from the Paris Agreement on climate change and sends a cable to its French mission, which then sends it and goes from there. That they are just simply another state in terms of the United Kingdom. Similarly, if the United States sends its ambassador or does not to Cuba, it is operating as another state. It is certainly possible for the US to operate as another state when US officials come to the UK. They aren't part necessarily of the mission unless they're on a special mission. And therefore, we can't necessarily link the fact that there is a document from the mission to say that therefore it's wherever that copy of that document goes around the world. I think that is beyond the scope of what the Vienna Convention says. So the documents of the US mission, once sent outside the United Kingdom, are no longer documents of that mission. In fact, if I could pick up a question asked by Lord Mance, what is the what is the purpose of the convention? The purpose that's set out in the preamble is about the efficient functioning of the mission. Now, a key role of that efficient functioning is to transmit information to their original state. But once it's there, once it's done that, that is the end of its functions. If their state then decides to send the document around the world, that is no longer a mission document or a mission function. And in fact, if the example which was given by the court about if there's a document from the mission given to the Foreign Secretary, we think about it from a different angle. Would that not be a very clever way for a state to protect its own documents? It actually does not. Let's say there's a document it does not want. There's no claim it can make under freedom of information. There's no claim it can make to prevent it being disclosed. You put the document through your mission. Suddenly, the Vienna Convention, if we take the extreme lengths to which the respondent's argument would go, would no longer be able to be available for a court to consider. That cannot be what this convention is intended to do. And of course, the case law simply doesn't support this, the argument of the respondent. Let me just take you to one case on that, which is, in fact, the case to which Lord Sumption has already referred to, the Court of Appeal in the Maclean-Watson, the Schumann-Lehman case, which is on page 2569 in volume 7. Now, so it's page 2569, and the first part of this, the respondent did read out to you. But if we then keep on going, it says, in the middle of that page, it follows, if the three documents shown to us as samples of documents issues are indeed typical of the rest, there are copies in the possession of the ITC of all the documents in issue. Those copies are fairly to be regarded as parts of the official archives of the ITC, wherever other copies may exist. But the official archives must, in my judgment, be limited to documents which are in the possession of the ITC. A copy which is no longer in the possession of the ITC, being of course based in London, cannot itself be part of the official archives, even if some other copies still retained by the ICT are part of the official archives. And the main consequences of that, in the judgment of Lord Justice Dillon, is that copies which have been sent by the ITC to its member states or their delegates or representatives are not part of the ITC's official archives, even though other copies of the same documents retained by the ITC in its files may be part of the official archives. A fortiori, copies made by persons other than the ITC of copies already sent by the ITC to its member state or the delegates or representatives are not part of the ITC's official archives. And if I could just press that point one more step, if we go to page 2579, in the middle of that page, this is Lord Mustall, who expressly agreed with Lord Justice Dillon. Lord Justice Mustall says, and as I say, it's pretty much in the middle of the page, it is surely stretching this policy too far to regard the United Kingdom as the host nation for documents held in the files of the economic ministries of governments dispersed around the world. I acknowledge that a document essentially archival in character will not necessarily lose that character by being displaced from the storage space at headquarters. But if the document is created in more than a score of exemplars, which are forthwith dispatched to all corners of the globe, I find it impossible to hold they continue to be part of the archives of the ITC, or that even if they have not been so whilst in transit, which is the point Lord Sumption just made, they once again become part of its archives when they come to rest in the files of the member states. So I would hope that answers the questions which you raised about how far does this go? And what I would...
The House of Lords adopted a slightly more sophisticated analysis, didn't it, in addressing a distinction between documents which had left the possession of the ITC with its authority and documents which had left its possession without authority.
They did, but they
And
didn't
they said
actually
the
deal
latter
with,
will remain part of the archive.
but they didn't actually deal with this specific issue about the copies in member states.
No, I mean, I think
That's
this
why
is
I've
dealing with documents which have left with authority.
Yes.
But are they only, there are two distinct questions, really. One, what is the effect on an immunity that would otherwise exist of the fact that it has been unlawfully abstracted? And secondly, what are the limits of the documents that can be described as part of the archive? Now, as I read it, the Court of Appeal dealt with both of those questions, but the House of Lords only dealt with the former. And one reason for that was that when it got to the House of Lords, a great deal more definition was given to the issues by the drawing up of a series of factual hypotheses and the making of a number of important concessions in the course of argument.
That is absolutely correct. In fact, a large number of assumed facts. But they weren't the assumed facts at the Court of Appeal in quite the same terms. That's why I've turned to the Court of Appeal, because this issue was not before the House of Lords. It was before the Court of Appeal, and the Court expressly make it clear they are different documents. So that, maybe just to take it one more stage, which is the respondent referred to the Unroe human rights litigation case in the United States. Just to say, I'm not sure that's relevant at all. It's a case of it's a case of freedom of information under US domestic law. It's not an issue of, at no stage was the Vienna Convention on Diplomatic Relations raised. So it is not relevant, I don't think, to this particular case. So my point, my submission is that the case law indicates that they may look the same as each other, they are not the same document for the purposes of the Vienna Convention on Diplomatic Relations. Otherwise, to make copies of every diplomatic document, wherever it goes and whether it's sent by the mission or sent otherwise, would mean you've got an extraordinary kind of cross-border web of international obligations which never stop on the receiving state, even if it's far from its own territory. And an extraterritorial response to the United Kingdom, as the respondent argues, in our view, is not what this convention is aimed at. And so our submission is that in this circumstance, the United Kingdom is not the receiving state under Article 24 or 27. It's not subject to them, has no obligations under the Vienna Convention on Diplomatic Relations in relation to this cable. And on that basis, the whole of the respondent's case falls.
Can I ask you, the basis on which you're putting the argument is that there are at least two copies of the cable in existence, one forming part of the archive of the mission in London and another forming part of the files held by the State Department in Washington. And you're approaching the matter on the basis, I think, that this particular copy that found its way into WikiLeaks is the American copy, the copy held in the United States.
The answer is we don't know. All we know,
yes,
the Divisional Court has assumed it didn't come from the UK mission.
Yes, I was wondering about that. I mean, obviously, you proffer the document on the basis that it's genuine, and therefore its admissibility has to be assessed on the hypothesis that it's a genuine cable. But is it for you to establish that it's one which originates in the files held in the US and is therefore out with the scope of the convention, or is it for the government to establish that it comes from the London mission and therefore is covered by the convention?
I'm not sure either of those issues arise, because if the decision of the document is admissible, it is then later, for evidentiary purposes, decided what weight to give it, whether it's genuine or not.
Yes,
admissibility
its admissibility its admissibility on your argument depends on what its provenance is.
Admissibility on my argument is on the assumed facts that it didn't come from the United Kingdom, and on those assumed facts, which are the joint assumed facts of both parties, and before the Divisional Court, then there is no proof at this stage needed. Simply, the issue is it admissible? Then on further cross-examination or whatever, then it can be tested about its authenticity, its genuineness, the weight to be given to the evidence. But actually on admissibility, that is not what's needed. Thank you. So my second submission is, how do we go about looking at this word inviolable? My submission is that if the convention applies, which, as I've argued, we don't accept, then the court must, in our submission, define the keyword inviolable in order to determine the issue before it. Now, I'm going to ask the court to turn to the Diplomatic Privileges Act, which sets out the relevant parts of the convention. If you could just hold that on a tab, because I'm going to come back to that a few times. And that is in the new file at part 6.
Yep.
My starting point is, of course, the actual two provisions in issue. Article 24 says the archives and document submissions shall be inviolable at any time and wherever they may be. Article 27.2 says the official correspondence submission shall be inviolable. Now, for all the arguments that the respondent has put on all sorts of variety, there is no definition of this word. The most we have is in the written case is it probably means inadmissible. But in the speaking notes, instead we have, there's a final acceptance that there must be a definition, though the approach is one of etymology and a blue pen, whatever that means. But that is not the correct approach for an English court to look at when trying to define a treaty term. And a word does need a functional definition. We can't just say that it's unnecessary. So our submission is then there's a need to define this term. And the only accepted way in our submission that the court should determine the definition of a word in a treaty is to follow established approaches to treaty interpretation as set out in the Vienna Convention of the Law of Treaties. So that's the second document which I'd like you to turn to and keep open. And that's at page 2638, which is in volume 7, page 2638, which is Articles 31 and 32 of the Vienna Convention on Law of Treaties.
Right.
I'm going to refer to it a few times. So,
which page was that again?
Articles 31 and 32, it's
2638.
page 2638.
Right. Thank you.
It's in volume 7.
Yep. Thank you.
It's rather lengthy, but as I'll show, we don't necessarily need to go through it at length. Just to say, these two articles are generally accepted as being customary international law, used across national and international bodies, and they are applicable in interpreting all treaties, including those considered before and after. And in any event, the courts of this country, as I show, have taken this to be the approach to defining a word of a treaty. And the core provision for our purposes is Article 31(1), which provides a treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in their context and the light of its object and purpose. And to give an example of how the courts have applied it, if we could turn to the case of the Crown and Hoxha, and a special adjudicator, which is on page 2466 to 2467. They're the page numbers which we'll look for. It's in volume 7.
The same volume, yep.
Same volume, it's just further down
Thank you.
sorry, further back in that volume.
Well, no,
The issue just here was the court was trying to define a term in the Convention on refugees, and maybe it's helpful to summarise the issues, which Lord Hope does in paragraph 5. So this is on page 2466. And he sets out there that the applicants claim that they have produced a compelling body of evidence which shows that the modern construction of the proviso to Article 1C5 of the Geneva Convention on Nations Status of Refugees is one which covers all refugees and is not limited in its application to refugees falling under Article 1A1, who are statutory refugees. He then says, in my opinion, however, one has only to scratch the surface to see this proposition is not based on any hard evidence. This is indeed what the proviso regardless meaning is a matter of legal obligation binding on all state parties, etc. And then further down on paragraph 9, refers to Lord Bingham, and then makes the point at the end of that paragraph, there's no warrant in this provision for reading into a treaty words that are not there. It's not open to a court when it's performing its function to expand the limits which the language of the treaty itself has set for itself. So what we have here is the House of Lords, even when dealing with a humanitarian issue, how far do they extend this important treaty about refugees, still said the way we define it is to look at the Vienna Convention on the law of treaties. I mean, one could say here that there is just as much a pressing humanitarian human rights issue in depriving the Chagostan people of their own land. But even though this is the situation, we would still urge the court that that is the way to define a term, by looking at it through these means. And simply by looking, as the respondent has, to a whole array of commentators, including two others who are the same commentator, doesn't advance us very far. And in fact, as you'll see in our reply, we have a whole series of other commentators who offer a different view. So what we need to do is interpret it in this way in our submission. So I don't intend to go through my submissions, my reply closely. I just want to make 4 points in this, so I'm not going to hopefully delay you. If you could just, if possible, if the court wouldn't mind looking at our reply on this issue, which is page 265 to 270. As I see it, there are really 4 points. The first one, this is page 265 to 270.
Yep.
And I'm, in a sense, going to rush through them because I assume the court has read this reply. If there is such an ordinary meaning, then if we look at the Oxford English Dictionary, it would define us to being not to be violated, not to suffer violence or force. Second, if we review the preparatory works of the Convention, which we set out there, we see that the terminology is that this receiving state should abstain from any interference by its own authorities or unauthorised interference by others. And third, the view of many commentators, as we put there, show that the terminology is about forcible interference, not about inadmissibility. And although the respondent has challenged us in relation to the Australian Federal Court case we show there, in fact, the issue which they refer to is simply the court is referring to a commentator. The court is not saying that there are any issues there about a court order being an interference contrary to inviolability. And fourthly and finally on this summary, our submission is that the term used in a treaty must be consistent throughout the treaty. The normal statutory interpretation, of course, as the court is aware, is that a word in legislation would have the same meaning in every place it occurs. A similar presumption exists for treaty terms. I won't turn you to it, but if you're able to, the court look at tab 4 of the additional documents, there's a statement by Richard Gardner in treaty interpretation, basically saying the same thing. The treaty term, one term in the treaty would be the same across it. So, to do that, if I can ask the court to turn back to what you had open, which was the Schedule 1 of the Diplomatic Privileges Act, setting out the relevant parts of the Convention, which is in volume 6, in the new file,
New file.
part 6.
Yep. Indeed. Yeah. We looked at that.
My point is a relatively brief, but
Understood.
let's look at, if we can, look at two other articles, Article 22.1 and 29. Both of them use the word inviolable. If we adopt the view of the respondent that inviolable means inadmissible, these terms do not make any, these articles don't make any sense. The premises of omission cannot be inadmissible in a court. The diplomatic agent can't be inadmissible in a court. It would be, to use the words of the Vienna Convention law of treaties, manifestly absurd. If instead we consider it to be you can't forcibly interfere with, it not only makes sense, it's actually consistent with the rest of the terms of each provision.
Well, he's not submitting that inadmissibility as the sole consequence of inviolability. It's only the consequence that happens to apply to documents, but, as you say, not to premises. I mean, this is a logical fallacy, isn't it?
Except that the term has to be applicable throughout and the same
Yes,
term be
but
used functionally in relation
You can
to
have an
the
inclusive term that may have a variety of different consequences in different contexts. Doesn't mean the meaning is different. It simply means that as applied to a document, inviolability has a different consequence to the consequence that it has as applied to the premises of a mission.
If I may say, the difficulty with that is that view would be that actually when an issue of inadmissibility is considered within the Vienna Convention, it is expressly made. Article 32.1 talks about the diplomatic agent cannot be brought into evidence. And so to add in a word inadmissible...
Sorry, 32.1.
Sorry, 32.1.
I mean, the logic of this is that if somebody burgled an embassy and stole a document, it never entered the public domain, but he just stole it and sought to put it into evidence in court proceedings, the English courts would have to rule it as inadmissible. Now, that consequence, whatever else one might think about the Shearson-Lehman decision in the House of Lords, which is in some respects not at all clear, but one thing which is abundantly clear is that they weren't having that. So do you say that
and the
decision
appellant
was
completely agrees with that position, and that's consistent with the notion of forcibly interfere with. It's either by the violator. And so if the forcible interference is by the state, the state couldn't rely on it. If the forcible interference is by the violator who's the party to the case...
Isn't it the case that Professor Judge Higgins gave an example of a document which was left by a diplomat somewhere outside the mission by mistake? There's no forcible interference there, but could that be used in evidence?
Well, if the state is not involved, if there's no forcible interference by the state or by a violator...
No, but somebody else picks it up and comes along and tries to put it in court. Wouldn't the court be obliged to say, this is a document which has left the mission archives by mistake, it's inviolable, we can't use it?
In that instance, we're talking about within the territory of the state.
Yes, well, that's a different point, and that's why I raised the instance. Right. But on your case, because there's been no violence, it's usable, and because it doesn't mean inadmissible, it's usable. I'm just challenging those two propositions.
I accept that the particular example that Professor Higgins raises a different issue. I don't think it raises inviolability. It may well raise a broader position of protecting the documents by the state, but it's not an inviolability because it's not a forcible interference with it.
Well, I mean, that's one view of inviolability. Another view, I think you use the word interference. I'm not quite sure where you got it from.
Sorry, I rushed past our reply, but our reply talks F.A. Mann, the distinguished, which I could say, doyen of international
with a rather restrictive view sometimes of the scope of international law.
Completely accept that.
Particular state immunities.
He makes that point. The Australian court I refer to talks about interference. Yes. Even Lord Bridge in the Shearson-Lehman case refers to interference. It is a term used again and again in relation to inviolability.
He's talking about interference with the privacy of the contents, which is a slightly different concept.
Completely accept that. So...
if the document is illicitly obtained, does that constitute an interference with its inviolability?
I think only in two examples. If it is illicitly obtained and then being used in some kind of court proceedings or used by the state, and it's within the territory of the state, both those things need to apply before it would be considered.
So that would impinge on its inviolability?
Yes, but it has to have those other conditions.
Yes, but that would answer my Lord Mance's example, wouldn't it? Where someone comes by it other than in an authorised manner.
Yes. I accept that.
And what this suggests is that there are certain circumstances in which the illicit abstraction of a document will not be treated as having taken the document out of the archives. But then, in a case like this, we have moved on to a different stage because it's not the abstractor who is trying to make use of the document. It's a member of the public who wishes to take advantage of the fact that the whole world knows what it says.
And on the facts, obviously, which we have here, which is, I think, what you're alluding to, it is not inviolable because
Well, the
there is no
violation has already
violence.
happened. There's nothing left to be violated.
Well, it therefore means the Vienna Convention does not apply. So if, in terms of, I would just have one clarification. The respondent seems to imply that if a court orders a document to be, from a diplomatic mission to be provided in court, that is inviolable. We don't disagree. That has to be. But this isn't the position. We're not talking about a document being requested by the state. There is no, as we'll come back to later, any issue of state compulsion. And so perhaps if I could just move on to the point that our second submission is basically a straightforward one. That in order to define inviolable, which is a key point in this, considering the Vienna Convention on Diplomatic Relations, the consistent approach of these courts is to use Article 31 and 32 of the Vienna Convention on Law of Treaties, and if we do that, and if we seek, as I say, in treaty interpretation, a consistent term throughout the treaty, then the word inadmissible cannot be usable, but that the word there has to be some degree of interference, potentially forcible interference, either by the state or by a violator who then seeks to rely on it. And that point about seeking to rely actually is also relevant in terms of, as we'll look at in a moment, there are some circumstances where the courts have said where, in a sense, the example Lord Carr gives, which is about where the violator either through somebody or directly has taken the document. So, as I say, the first two submissions doesn't apply at all. If it does, we have to look at the definition, and that would show that it's not inadmissible. Our third submission and final one is that if we look at each of the arguments by the respondent, none of them show that a diplomatic document of the US, which was copied outside the UK mission, was distributed outside the UK mission, was put in the public domain, not through any act of either the state or the appellant. None of them show that that is prevented from being admitted into evidence.
Can I ask how that submission operates in the electronic world? Suppose, as is not uncommon, that a government has a comprehensive, say, cloud-based system of document storage, so that we're not talking about physical documents. The same text in the cloud can be downloaded by the State Department in Washington or by the embassy in London. Now, what constitutes, in relation to that document, the archive of the mission?
I guess I have two answers to that, and I think Lord Reid also raised a similar point. If the archives of the mission are within the territory of the state, it is clearly receiving state's responsibility.
So
but in your example, what if the archives of the US mission actually happen to be held in Texas in the United States? In those instances, that is where the archives are of the mission. But a copy of those archives sent elsewhere by the State Department are not archives of the mission.
So you look at where the server is, do you?
Possibly. I'm not. I'd have thought the issue is not where the server is; it's where the storage facility, which is the terminology, is. And if that storage facility happens to be in the United States, then that could be where the archives of the mission are. But if the US State Department then sends it elsewhere, that is no longer a document of the mission. And if those let's say that iCloud, and these days I think we must all be slightly nervous about putting documents in that location, is there's an issue of, where somebody steals from that cannot be the receiving state's responsibility. It cannot be the United Kingdom's responsibility that a storage facility or an electronic facility somewhere else in the world is broken into. It becomes a receiving state responsibility. That is an issue, as in this case, of the national security protections by the sending state. I think they're two different issues. It doesn't fall under the Vienna Convention in terms of consequences to it, because there is no inviolability. So in our reply, which if the court has it in front of them, our reply on all these 7 other points thrown at us by the respondent, from page 272 to 294, once again I just hope to make a brief point about each of these 7 arguments. The first one, which in some ways we've already touched on, is Lord Bridge and Maclean Watson. Our submission, and it would seem that the court is comfortable with this, is that either it was obiter dicta or it was dealing with a different issue, dealing with documents of an international organisation and therefore not relevant to the issue before us. Second, in relation to the respondent's argument of state compulsion, he now says in paragraph 21 of his speaking notes that it's a term he invented. It's not a term of art, it's not a term of law. It's not a term I'm familiar with in those terms. In any event, there is no state compulsion. The court here is not forcing the US mission to provide a document. In fact, they're not even asking the US court to authorise them, as I hopefully explained in my answer to Lord Reid. There is no requirement for the US to intervene in the case. The documents are already in the public domain, and there have been many cases in this country and abroad, as we have shown in our reply, such as Stolen Switzerland and the Republic of Djibouti and Boré, to both of which I will return.
Just on your first point, if it's part of the ratio, have you asked us to overrule it, and which bit are you asking us to overrule? What precisely is the objectionable bit?
The difficulty which the respondent raises, Lord Bridge, is when he dismisses the argument from Sidney Kentridge, and that is in paragraph 28 of his case, which is at page 224. And in that case, which is, volume 1, so at page 224, the respondent refers to where Lord Bridge responds to, sorry, I'll get the right page myself. Got it, thanks. Refers to Mr. Kentridge's arguments, presented a forceful argument about the defendant's basic proposition.
As I understand it, the bit you're objecting to is the extension of the case to prohibit use in evidence of documents which come from the archive or which have been abstracted from the archive without authority.
That is exactly correct.
Well, it's only the latter, isn't it? Because if it was abstracted with authority, I think that the decision was that it could be.
Yes, exactly. I mean, that's the distinction.
Thank you.
The distinction between with authority and without. So if it's either within the archive or has been abstracted without authority. So you say that's wrong, but I mean, it is, on the face of it, this seems to be part of the ratio, because they were asked to decide a number of hypothetical questions and they decided each of them, so the decision on each is ratio. And on this particular point, this was the one issue in respect of which Mr. Kentridge lost. Or admittedly, they went on to say that it was likely to be of minimal significance, but they nonetheless did decide it.
If I accept that is part of the ratio, I would still argue it is not pertinent to this case.
Yes, well, I got that point. I mean, but you're not really submitting that is wrong. So we can.
I am restricting it.
I think you're saying you don't have to submit that.
Quite. Quite.
Yes.
You adopted paragraph 37 of the Court of Appeal's judgment on this point.
Thank you.
I mean, the Lord Bridge was concerned with the question whether a document ceases to be part of an archive if it's unlawfully abstracted.
Quite.
We are concerned with the next stage after that, namely, what is the... Does it also remain part of the archive where not only has it been abstracted, but it has been published to the world? And Lord Bridge wasn't concerned with the impact, if any, of publication to the world. But that's rather critical in our case.
That's correct, Lord Sumption, and of course that's why I took you to the Court of Appeal, which would consider that because it wasn't relevant before the House of Lords.
On the two stages, I mean, the first question is whether, if it's published to the State Department, it remains part of the archive, and you say no. And I suppose then, even if it did, you would say, well, once it's published, that's a different ballgame, but that might be slightly more questionable.
In a way, I don't think we need to go that far.
No, you don't need to go that far, because you just simply say it's not part of the archive anymore.
That's
it's
as far as we
abstracted
need
from
to go.
somewhere on the face of it.
It is not an archive.
State,
document.
dependent department, or somewhere else, yes.
I accept that.
I suppose if it was abstracted from an American, sent by the State Department or someone to the American embassy in Iraq, but you say it wasn't. That's the one thing that it isn't that right?
We don't know, of course, but whatever it definitely didn't come out of the UK mission.
I mean, that I think we all know from having read the newspapers that is so. Is there actually material that demonstrates that in the material before us?
I don't think there is. I think it's agreed. I think it was just assumed, it was one of these assumed facts. I don't think we actually...
All along that this has never been an agreed fact.
The answer, it hasn't been, it has not...
We just
been
don't know where it came from.
It's
The
been
question
assumed.
therefore turns on the burden of proof.
Yes.
Which is then relevant once the cable is admitted. Then that can be a matter for discussion.
This is a point I put to you about half an hour ago,
Yeah.
and it seems to have come back. I mean, if you're proffering the document on the footing that it's genuine and its admissibility depends on its provenance, is it for you to establish that its provenance is such that it is outside the scope of a convention? Or is it for the government to establish that its provenance is such that the convention applies?
I think there are two answers. It has to be for the government is the second is the answer to the second part, but in any event, that is not before the court now. Before the court is whether it's admissible, and I would argue it's not inviolable. And inviolable is defined by hasn't been interfered with by the state or by the violator. Then there is no issue about admissibility. It should be admitted, and then at a later stage there can be that exact discussion.
But at the moment, is there any issue as to whether it is what it purports to be?
Neither confirm nor deny.
Yes. Thank you.
Prima
Thank
facie,
you.
surely.
So you just look at the document and you say, well, this on the face of it looks of it. And then the judge says, well, on the face of it, on the balance of probabilities, that's what it is, absent some...
Except that it's a bit more sorry, my lord.
The ordinary rules of evidence are that under the Civil Evidence Act, a document is evidence of its contents and its authenticity can be proved by reference to the document itself.
Right.
The court can draw inference from its appearance and so on. Now, that being the basic position about documents generally, somebody must have the burden of establishing that this document is different because it's immune. And on the face of it, one would expect it to be the person who's asserting that it's immune.
Right.
I think we don't need to get to that stage at this
Yeah, but what's wrong with that as an analysis?
You don't
think
want it to be
makes-
wrong.
Yes, quite.
I think that would be
Would it be
consistent with our argument.
I think it would be.
But I think you'd submit in any event, even if the burden was on you, it is discharged because of the inviolability argument.
Thank you. I will accept that as a good
I think
answer.
we've had enough of this point.
Maybe it's helpful at this point to turn to a case which might show actually how this is working out. And that is the case of the Republic of Djibouti and Bore, which you will find in, I can find it, on page 2188, which is in volume 6, 2188. The reason I turn to this is because this is a claim brought by a state against an individual and his companies based on alleged improper conduct, including alleging of bribery, in which WikiLeaks cables were used. And this is before the English Commercial Court. And here we have not only the WikiLeaks cables being admitted, considered very closely in the evidence as to the truth of their comments, and in fact preferred as the truth in relation to the witness of the foreign state. I'll just turn to one example, and that's on page 2207. I think that's right, page 2207, which is in volume 6. And what we see here is paragraph 77. Mr. Justice Flo held, Mr. Ismail Tani was the former director of the government newspaper, La Nation, and Secretary General of Information. Then he goes on to say, he clearly knew about Mr. Borré's shareholding in Horizon in 2004, not least because when asked about it by the US ambassador, he said, of course, Mr. Borré had shares. But, and this is a key clue, but, when confronted in cross-examination with the relevant WikiLeaks cable from the ambassador reporting her discussion with him, he simply told a barefaced lie to the effect that the discussion was about Sopran. Now, why is that important? Well, it's first important because an English court has admitted into evidence WikiLeaks document, allows them to be used in cross-examination, and in fact preferred that evidence in a case after the Court of Appeal case. Secondly...
Was the point argued?
If I could just come to that in just a moment, Lord Sumption. What we have here, one of the parties was a state. That WikiLeaks document concerned that state, Djibouti, and the WikiLeaks document was not obtained by forcible interference by the state or the party relying on it. And that state, at no stage, argued the Vienna Convention of Diplomatic Relations. Why is that important? Well, if you go back to the very first page of that case, which is page 2186, we have very senior legal team representing the government of Djibouti who have taken an international law point in that, I won't go to it, but they took an international law point saying the president wouldn't come and be a witness. And yet they do not argue this, because it is not relevant. In such a situation, the Vienna Convention of Diplomatic Relations is simply not relevant.
Well, it's a sort of Homer nodded point.
Sorry?
It's sort of Homer nodded point.
It has to be consistent with our case, isn't it? That there we have no argument. And what we find...
Well, the United States wasn't party to...
The state was a party, the state of Djibouti.
Not the United States.
It's not a party to this case either.
Whose documents... I mean, from who? It's the US Embassy archive from which this appears to have emanated. Now, whether you take a point like that or not may depend on whether it tactically suits your case.
But in fact, it did not suit the Republic of Djibouti, because in fact, the US ambassador's WikiLeaks document undermined the Djibouti's own witness.
Well,
I feel in my bones that this case is not going to depend upon what view we take of the Djibouti case. That's my only view. Yes.
I understand that, except it builds on a pattern. We have a lot of cases, and the respondent refers, in fact, the respondent says there are no cases which show that states are taking this point. Oh, sorry, that parties are taking this point. That, of course, is good state practice to show there is no application of the Vienna Convention on Diplomatic Relations.
Wait a minute. I mean, sure, state practice requires a bit more substantial.
There's no practice. Sorry,
anyway, Lord Faulkner of Thoroton is not the state.
There is no practice which shows that
American state ever.
that there is an argument for the application of the Vienna Convention on Diplomatic Relations to an instance where there is a WikiLeaks document in the public domain where the party relying on it has not been involved in the violation. If I could just make two other quick submissions before I finish, one of which is, as we've already noted, that we do not consider that the obligations under the Vienna Convention on Diplomatic Relations extend extraterritorially. And secondly, that even if, which we do not accept, that the cable was copied in violation of international law, it does not follow from that that it cannot be included in evidence. And for that, I won't read, but we refer to the case of Excess Ethiopia and the Secretary of State for the Home Department, a decision of Lord Justice Richards, which is set out in our reply, paragraph 76, and you can find it on page 4529 to 4530 in volume 11. Therefore, as I say, our argument is that for all the many arguments made and unmade and remade by the respondent, none of them are directed to the issue before us. None of them show that a document which is copied, sent by the US government, not by the mission here, not a document in the archive of the mission here, where neither the UK government nor the appellant have been the violator, that none of those arguments by the respondent show that the document cannot be admitted in this court. We would urge to uphold the decision of the Court of Appeal that the copy of the cable be admitted into evidence. Are there any further questions?
Thank you very much, Professor McCorquodale.
Thank you.
Well, Lords, it may be helpful to consider the matter in four stages. First, does the document ever become part of the archive? Does it ever become subject to the Vienna Convention at all? Our submission is on the facts of this case. The answer to that question is clearly yes. The sending state, the United States, the mission state, the embassy in London. The document was created by the embassy in London in the discharge of its diplomatic functions, and the core rationale for the convention is to facilitate the communication between a home state and its mission, and that's exactly what this document was created to do. So we submit, and it's not clear whether or not the appellant disagrees with this, that there was at least a point when this document was part of the archives of the mission in London. So the Vienna Convention did apply at least at some stage. If that's right, the question then arises, has it ceased to apply?
To the original. You're talking about the original document, the one actually written by the political counsellor.
To get within the first stage, I only need to refer to the original document. To deal with the other stages, then I have to deal with copies as well.
And also, I mean, it was sent apparently to the US Embassy in Mauritius, for example, and Diego Garcia was sent to, I don't know whether that counts as an embassy or not, it's US territory probably. Anyway, it was sent to Mauritius, so it was presumably part of the Mauritian archive. If you could show it was abstracted from in Port Louis, that would be different. That's the point. But it's not suggested it was.
Yes.
But it's suggested that it's more likely to have been abstracted, I think, from a military base in Iraq.
Yes. Well, we come on to the second stage, was whether or not the fact that copies of a document mean that the original, even though it remains in the mission, ceases to be part of the archive simply by virtue of the fact that a copy exists which is in the possession of the home state, to take the simplest version of the thing. And I took you to some of the authorities on this before, and I won't spend any time taking it now. But to take another example, and I'm sorry if this seems as facetious as the dog one, say that the original is kept in London, one copy goes to the State Department, and it's on the file in the State Department. As I understand the argument against me, the fact that there exists a copy in the State Department means that it has ceased to be part of the archive in London in the mission.
No, I don't think that's the argument. Surely the argument is that the copy that's in the State Department is a distinct document, so that you've got two documents. The copy, the original in the London Embassy, is undoubtedly part of the archive. The copy in the records of the State Department is not.
Well, I'm not sure that the appellant accepts that the copy in London is still on the archive, but let's assume that I'm right on that.
Let's assume
that the court does. So it's accepted that the Vienna Convention does apply at least to the original.
Yes.
And the burden of my argument at all its various stages is that, all the more so in this area of cloud storage and electronic copies, it is irrelevant where one particular copy is located. What matters is the content. And if the content relates to a communication between a home government and its mission, that is what the Vienna Convention is designed to facilitate and designed to make inviolable. It is the content of the communication, not the location of a couple of data bytes, which may be in the cloud in anywhere. So my submission is that, assuming the court is with me that the original in London remains subject to the archive, that is what matters for my part. And for the logic of my argument, the fact that there exists on the State Department file in Washington a further copy, the copy itself as a copy will be subject to US law, as we saw from the ACLU and the Unroe case. But the fact that it remains as part of the archive in London means that we can't dismiss the Vienna Convention from consideration.
But that means it's sort of one-way traffic. Communications from London to Washington, you can't use a copy which comes from either end. But communications from Washington to London, you can't. Do you suggest that something sent from Washington to the London Embassy is part of the London Embassy's archive?
Yes, because if we go back to the rationale, it is to facilitate confidential communication between a government and its mission abroad.
But the copy retained by the State Department of the letter it sent to the ambassador in London, you say that copy, which has never been anywhere near the London Embassy, is also protected by an immunity for the archives of a diplomatic mission, do you?
Well, what I'm seeking, and I appreciate your Lordship may disagree with me about this, but what I'm seeking is that it's not the copy that matters, it's the content that matters.
Then how would you define the content? Are you saying that some of these documents, which on the face of it would be covered by the convention because of their source and their location, aren't covered because they're not really diplomatic communications? So how would you define the content that is covered, wherever it may be in the world, and however much of the world knows about it?
I'm not sure that requires a separate exercise. If it's accepted at my stage one that the original is part of the archive, that's all I need. This case has not turned on what the definition of a diplomatic communication is in the first place, so we haven't explored the outer limits of that. But if it is common ground that the original was part of the archive, that's all I need.
So would it be possible if a diplomat, if an American diplomat voluntarily gave evidence, would he be precluded from giving evidence about matters which were the subject of a record in the embassy?
This was touched on Fayed and El Tajir, where they didn't need to resolve it, but they did flag that up as an interesting question which they didn't need to answer.
Because on the face of it, it's turning the inviolability of a collection of documents into a privilege in respect of particular categories of information, a kind of foreign state public interest immunity. And that seems to be a little different as animals go.
Well, we've seen from the American litigation that there is ample opportunity to litigate the confidentiality of a US document in a US court, subject to US law. So I hope that that is the means to address that particular concern, because to deal with the question whether the State Department, which is the representative of the American government, is entitled to keep this material confidential, that has been litigated in a US court, and that question has been answered by a US court. It is both consistent with that decision of the US court and with the United Kingdom's own obligations that we do not, as a United Kingdom court, take it upon ourselves to breach the confidentiality of that communication by omitting it in evidence and making a finding of fact that this is an authentic document. And can I break off at this stage to make a separate point, but it's an important point about the facts. A number of times it has been said, well, this is in the public domain, and the legal consequence from that is that the violation has happened. Factually, it is not in the public domain. This is a crucial factual distinction to understand. What is in the public domain are the newspaper articles. The cable is not in the public domain. What we know from the American litigation is that there exists a cable. What that cable says, we do not know.
It's the document, or a copy of the document, is downloadable from the WikiLeaks site, as I understand it, which is what essentially the newspaper's got an advanced site of it. But as I understand it, the WikiLeaks site enables you to download any of these documents.
That's precisely the argument that the US courts rejected. It doesn't matter if it's on WikiLeaks. WikiLeaks doesn't authenticate the document. That was the very argument rejected by the US courts.
But the problem is you have got to demonstrate, if you start putting this on the basis of the confidentiality of the contents, then you've got to grapple with the fact that they aren't confidential anymore.
Well, that's what we don't accept. That's the whole sting of the authentication point, which is why the violation is not over. The violation that we are concerned about, the violation that is relevant to this case, is not whoever leaked it in the first place. The violation that we are concerned with is the violation that will be carried out by the English court in admitting it in evidence and authenticating it, and therefore saying that it's not just a newspaper article. So the argument would run, this is actually a true copy of the document. That is the violation.
Why is it a violation? In the American cases, the administration was being asked by order of the court. What was being sought was an order that would have required the administration to authenticate what were on the face of it its own documents. What would happen here is that the court would be exercising its power under the Civil Evidence Act to draw its own inferences from the appearance of what was put before it about whether it was authentic or not. I mean, is a mere finding of fact without any compulsion against the original owner of the information a violation of the archive, a violation of the confidence? What is it a violation of?
In my submission, the analysis is this. If the United Kingdom, through whatever organ, be it the executive or the courts, but the United Kingdom itself published the document, which was ex hypothesi in part of the archives, that would be a breach of Article 24 and 27. It would be a violation because it would violate the confidentiality of the archive. And analytically, my submission is there is no difference between producing the documents and making a finding of fact in a court of law that this is the authentic document. Both of them are equally damaging, and both of them amount to saying this document, which is a diplomatic communication that was once is part of the archive of the mission, this is nevertheless a document. Producing part of the archive is the violation. And that's equally done by authenticating a newspaper article as it is by issuing a subpoena or requiring the original to be produced. In both cases, the confidentiality of the communication between a government and its mission is what is being damaged. And if you look at it from the government's point of view, they want to be able to communicate in confidence. And that wish is frustrated equally by somebody stealing the original document, never mind about copies for the moment, as it is by a court in another state, the receiving state here, making a finding of fact that this is indeed an official document. Because while it's a newspaper article, you can neither confirm nor deny it. Once a court says this is the authentic document, that becomes frankly untenable. That's why the violation is the authentication. And that's a matter that's not dreamed up in this case. It's dealt with by the government white paper in 1998, dealt with by the Law Commission too in its current consultation. It's the very point accepted by the United States Supreme Court. So we're not the odd man out in putting forward this authentication argument here. That is why it is crucial to bear in mind that the focus is not on who was responsible for the leak. The relevant violation that we're concerned with is the authentication that's being asked by to be made by the English court. And two specific points on the references in relation to the authentication point. If I can ask you to turn up the speaking notes. Sorry, I'm getting my notes, not speaking note. The case, it's 225, volume 1. It's the case, and it's paragraphs 33 to 37. And there we have the references. In paragraph 34, we refer to the current Law Commission consultation and report at 3331 in volume 8.
Sorry, paragraph 34, you...
Paragraph 34 on page 225 in volume 1.
Oh, I'm sorry. Yes.
Sorry, no, I wrongly said speaking note, I meant the
Sorry
case.
about that, yeah. Right. Yeah.
We see, if you pick it up at 3329, you see a heading just above 3198, prior publication. And then you see the white paper is quoted at 3199. And then at 3200, the Law Commission in their current report say this: although this example has been described as chilling, we believe there is validity in the argument made in the white paper. For example, a website could publish a list of names of individuals as it asserts collaborated, colluded with the authorities in Northern Ireland. If an individual within government confirmed the validity of those names, it could magnify the damage caused by the initial disclosure. And then the rest of the paragraphs leading to provisional conclusion 15 at 3204, we provisionally conclude that a defence of prior publication should be available only if the defendant proves that the defendant in question was in fact already lawfully in the public domain and widely disseminated to the public. Do consultees agree? So it's the Law Commission that also does regard authentication as an important point. And this relates back to comity. If the United States government and the United States courts have also ruled that authentication is an important point, it is uncomfortable for for an English court to take a diametrically opposed line and say, well, it's in the public domain, we needn't worry about that, it doesn't matter. And that passage from the white paper, obviously not the Law Commission report, but it wasn't before them, was cited by the Divisional Court. I give the reference to that in paragraph 35. And then at 36 and 37, I give the references from the two American cases. On the similar point, and linking back in with the point about copies, if we can look at Professor Denzer in volume 8 at 3246.
Three, two, four, six.
3246. She makes the point towards the top of the page. It should be noted that the mission does not have legal personality. Archives belong strictly to the sending state. And that's a further reason why I keep jibbing at drawing a distinction between copies on the State Department file and copies in the mission. The legal personalities, they're all copies of the state. What is relevant is that they were created as part of diplomatic functions by being a communication between the sending and the receiving state. To pick up one point of detail on clarification in reply to Professor McCorkadale, the respondent's position hasn't changed about customary international law. There are two propositions here. One, the Convention changed what was previously customary international law. And two, it is the Convention which is the relevant public international law to look at now. Now, whether you call the Convention customary international law is neither here nor there. But it's not a question of either disagreeing or agreeing with what customary international law is. Our case is and always has been that what you need to look at is the Convention. Another point in reply to Professor McCorkadale, in Shearson Lehman, it is important to note in the relevant parts of what I think is now accepted to be the ratio of the case at 2541 in volume 7. What Lord Bridge says at the end of that passage, just above letter H, if that privacy is violated by a citizen, it would be wholly inimical to the underlying purpose that the judicial authorities of the host state should countenance the violation by permitting the violator, and these are the words that I now emphasise, or anyone who receives the document from the violator, to make use of the document in judicial proceedings. So Lord Bridge is clearly does not have in mind only the thief, but anyone from whom the document is received. And that's because the key focus of attention is not the theft as such, it's the use of it in the legal proceedings by the court.
There's a rather interesting statement, 3246, referring to Professor Denzer's own expert evidence to a congressional committee.
Sorry, Mark, can you give me the page again?
3246.
3246.
Yes. She appears to have given evidence to the effect that the inviolability did not apply to copies of embassy documents in the hands of firms of professional lobbyists. If I'm reading this correctly. They were lawfully in the hands of the...
Yes, I think that's the point here. It's all to do with lawful disclosures, because clearly if there is a lawful disclosure by the state, not to divide up any further, then the state can't have its cake and eat it.
Well, except that the state has supplied a copy to its own lobbyists on what would quite clearly have been, by implication, if not expressly, a confidential basis, so that the lobbyists could assist the embassy. Nevertheless, it appears that they ceased to be part of the archive, which was inviolable.
Yes, I mean, I'm looking at the sentence, the documents in question related to the professional services performed for the embassy, but it was not claimed that they were in the ownership or possession of the embassy.
It's not clear they ever have been. I mean, it seems they may just have been the lobbyists' own documents, own records relating to the professional services they had performed for the embassy.
Yes.
Yes.
In which case it's difficult to see how they could be
Yes.
the archives of the mission at all.
Yes, so your Lordship is quite right to ask me about this, but I'm not sure that we can resolve that.
How are we getting it on in terms of time?
Well, my Lord, I think subject to any questions, it's probably sensible for me to call a halt. I'm conscious that I haven't by any means taken you through all the references, either in the speaking notes or in the case. I know your Lordships do understand that I do rely on them, but I do need...
The fact that you haven't referred to something that's in your speaking note or in your written case doesn't mean you're abandoning it. On the contrary, if you haven't referred to it, we should make a point of reading it. I understand.
Thank you. Then I'll sit down, my Lord.
That's very helpful, very realistic. Thank you very much indeed. Thank you. Mr. Fleming.
Lord, I'm conscious I've got 11 minutes to bring all this together.
Well, you might have a little bit more, but if you do it in 11 minutes, we'll be faithfully impressed.
I can't, my Lord, but I will do what I can. Could I just get rid of one point on the cable that came up from listening to my learned friend? You will recall, or may not recall, how this all started. This started back in the divisional court in the middle of questioning of Mr. Roberts, when Mr. Kovacs stood up in volume 3, page 915, at page 104. The cable is a US diplomatic cable, therefore we rely on the Vienna Convention. And that theme continues. Paragraph 10 of his speaking note says, the actual cable was produced by the US mission in London. So we have all been proceeding on the basis that the government's case is that this is a copy of the actual cable that comes out of London. I understand, I was listening to Professor Corkadale, that one document hadn't been handed in paragraph 117 of his reply, page 287 of volume 1, there is reference to Article 33 of the Vienna, the VCCR. Could I hand up or make sure copies are handed up for your files? Having now wasted one of my minutes, could I get on to the substance of the case? And could I start by correcting or clarifying, because it's very important for our fisheries argument, that my learned friend, if he'll excuse the pun, rather ran aground when dealing with the different types of fishing. So could I just clarify that? There are two subheadings and three main types. The first is the Mauritian-only inshore fishing. That's proximity to coral reefs where the fish live around the islands and within the territorial sea, which should be 3 nautical miles. So that covers all of the fishing with which we are concerned, the lagoons, the internal waters, and on the submerged banks. And there you're fishing for demersal, bottom-living species. Handlines using multiple hooks with a mother vessel, either with hooks from the mother vessel or with dories, up to 20, I'm told, with several fishermen on board. This is the fishery with which we are concerned. This is the fishery described by Mr. Sakier and Mr. Volley and Mr. Talbot when he was being interviewed by Miss Yeadon back in 2009. The other fishing is divided into two. That's pelagic, open water or deep water, more than 12 nautical miles from any islands,
mainly concerned with French, Spanish, Chinese, Taiwanese, etc., and they're looking for tuna mainly. That's divided into purse seine. It's the large surface trawl. It encircles the fish. The side of the purse is closed. You have your catch. The second are the long liners, very long, deep lines, and they're either after a bluefin or deep water tuna. Now, what we're concerned, as I've said, is inshore fishery, which is relevant to the description in the arbitration award and the eventual finding that there was an agreement, an undertaking that Mauritius would be able to carry on fishing its traditional fishing rights within the territorial waters. And what has also happened is, since 1965, the extent of control over waters has changed. You'll see that from the history. So that we've moved from control over territorial waters eventually to EEZs, economic exploitation zones, which have extended. A good example is around the Falkland Islands, where the British declared 250 miles around, and we've done a similar thing in relation to the Chagos Islands. Just a couple of very short points. It was suggested by my learned friend when going through his trawl of documents that there was public knowledge during the consultation process of the 1965 Lancaster House undertakings, sometimes called mistakenly understandings, but undertakings. Now, he seemed to be suggesting that that information was readily available. But what you've seen from the evidence, particularly by Mr. Dunn, is that it's very difficult stuff to obtain. It was not available on the consultation links, not on the site. There was nothing to alert those who were consulting. Another very short point, qua Chagosians. A couple of times another friend referred to Chagosians qua Chagosians. There are no Chagosians save by heritage because they were exiled. They are either Mauritian, Seychellois, or British. So when we're talking about Chagosians, we're talking about those in the fishing area who are exercising the fishing rights of Mauritius because they either own the boats which are registered in Mauritius or they work on the boats. They cannot now step onto the islands and fish around the islands themselves. So when there's talk about qua Chagosians, one has to be really careful, because in the consultation, this is a misleading paragraph. When you will recall that the only reference to the Chagosians is the Chagosian community. And in the 5th of May document, there's reference to the Chagosian movements. What we're concerned with, the Chagosian people who came from the islands and their descendants, about 1,700 who were exiled. The population is now 3,000 or 4,000. On improper purpose, could I just spend a couple of minutes in light of what was being said to bring this back together? We're talking about fishing, which is a vital part of the history of the people who lived on these islands. It's vital since they were exiled. That's how they have maintained their living from Mauritius, and without that living, they're back into near destitution. And it's vital for their future if they ever go back. And we've added to your file, in file 5 or on your desks, a document that 5 of you will be very familiar with. I apologize, but not too half enthusiastically. I put in front of you Returning Home, because that's a document that's been mentioned more than once. Returning Home is not a leaflet, as described by my learned friend. It's a serious work of research that was put, it's in tab 11, I hope, was put to express in detailed form the case for settlement and return. And fishing features very strongly. Pages 17, and then pages 21 to 23. So it's past, present, and future, central to the Chagossian way of life. Part of the answer to our case on improper purpose is there could be no improper purpose because the MPA was entrenched. And that's a phrase used by Mr. Roberts to explain why he could not have had an improper purpose, used in the judgment. You'll see it in the Court of Appeal at paragraph 82. And my learned friend raised it. This is not entrenched. Lord Sumption asked the question, but it can never be entrenched. Silence from Mr. Kovacs. We don't have entrenchment in legislation. We don't have entrenchment in terms of impossible to repeal or particularly difficult to repeal when it comes to
Well,
things.
you could do something that was irreversible, factually irreversible.
Well, that's what I'm trying to get to. What they were doing was creating a situation where the historical fishing was to end, so that the lobby, that the counter-lobby, called in conversations outside this court as a greenwash that goes over the claims for resettlement and to return, because there is now a strong environmental lobby will say, don't let them back to settle because they'll start fishing again. And that becomes its own permanence. And the resistance to the international award, which I'll come to at the end, is an indication that this country, the United Kingdom, is pretty determined to keep these people away from enjoying their fishing history around the islands. So what we have in the long term, consistent with what is recorded in the cable, is that this will have the effect, it has the purpose and the motive to prevent, undermine, damage, however you put it, claims for resettlement. And it's not just talking about legal claims, it's talking about political claims, and it's talking about requests made by Chagossians to the British government, either themselves, direct, or through Mauritius. If one goes through this history, you will also see what stands out, that as you get to 2009, when you get to the consultation, the option that should have been offered to the consulting people, based on what we know now about the Mauritian fishing rights and the Chagossian history, and the state effect of these constraints on the Talbots and others, is that there was no option of restricting fishing to the inshore fisheries. It's the one thing that wasn't being offered. And if you look at the various options in the consultation document, having now read what you have read, it leaps off the page. Something is missing. Something is not being communicated.
What about the fact we're told that the award is going to be complied with? What does that mean in that respect? We'll continue to work with Mauritius to agree the best way to meet our obligation to ensure fishing rights in the territorial sea, so far as practicable. So it's all going to be catered for.
2 years, 2015, March.
When was this statement made?
This statement was made today, effectively.
Oh, I see, today.
That's, I assume it's today. We hadn't heard of it until it was read out yesterday. The misunderstanding of the international award is, I can just deal with it in one phrase. My learned friend sees this as a procedural criticism, a failure to consult. The significance of the failure to consult is because of the finding that there was fishing. And what you didn't see emphasized is, for example, volume 4, page 1431. And let me just link 3 paragraphs together, and I'll of course leave you to spend happy hours reading through the arbitration award. But this bit was just not touched on by my learned friend, and you can see why. Page 1431 of volume 4 is paragraph 449. And this is why there should have been a restoration of this fishing within days of 2015. The tribunal has found that the United Kingdom's undertaking regarding fishing rights was legally binding on the United Kingdom, yet the parties remain in disagreement. And then you go through it, And you get to the conclusion at 455, 2 pages on. In the circumstances, the tribunal is of the view that Mauritius enjoyed rights to fish in the waters of the Chagos archipelago, in particular in the territorial sea with which the tribunal is solely concerned, subject to licenses freely issued. And towards the end, there's reference to discretion. My learned friend didn't read the last sentence. He only referred to the discretion. Such discretion was nevertheless to be exercised consistently with the obligation to ensure that fishing rights would remain available. Now, with those findings, if you go to the...
What paragraph?
Paragraph 455, my Lord.
Oh, yes, right.
If you then go to the concluding paragraph at page 1467, paragraph 547.
Paragraph what?
Page 1467, the dispositif, paragraph 547.
Yeah.
Then one understands what is being said. It's at B. In relation to the merits of the parties' disputes, the tribunal having found, such as 449 and 555, that the United Kingdom's undertaking to ensure that fishing rights in the Chagos archipelago would remain available to Mauritius as far as practical is legally binding insofar as it relates to the territorial sea.
And that's the 12-mile period.
So it's 3 nautical miles.
That's the
Leonard's description was just a bit out. But then it's the declaration that there are breaches, because the existence of those legal rights meant that the consultation process, the good faith process obligations were all breached. But the starting point is the finding that there were rights in international law. So
one might say, well, what more do you want? Here you have a declaration in your favour, as it were.
well, my Lord,
I mean, I suppose you can say, well, if it's said only to be operative in the international sphere and not in the municipal sphere, but they say that they're going to...
But they haven't. My closing words at the end of what is meant to be the next 15 or 20 minutes is to say, we expected after March 2015 for Mauritian fishing to be restored, and therefore for the Chagos fishermen to fish. But nothing's happened. And now you see in the statement, it's because there's obstacles being put up by Mauritius. How do we know that? Well, it said that there are obligations to consult. That's at the end of this judgment, at the end of the judgment of the arbitral award. So that's why we have to turn to the courts, because without some order of this court, nothing's going to happen. And that's why we persist. We said in the early afternoon of the first day, we would be content if there was restoration to the position before the MPA in relation to inshore fishing.
Well, does that mean that you would be content with an adjustment to the MPA, or do you seek a declaration that the MPA is unlawful?
But we seek a declaration that it's unlawful. If they then want to restore with reconsultation, we'll have a few things to say. But if the position the court adopts is that if there is full restoration to the situation as it was in the middle of 2009, then we will have got the relief that we were seeking from the outset. And it isn't just, one has to be careful, not that I'm suggesting that there's any reason not to trust the British government, but it isn't just the proclamation. There are various other laws that would have to be looked at carefully to ensure that free licenses are restored, inshore fishing is restored, and the sakirs, the volleys and the talbots can go back to what they were doing.
Do we have a precise formulation of the relief you are now seeking in light of where we are today?
No, my Lord. The relief that we seek is to a declaration that the MPA is unlawful, because we have a series of grounds. We can try and formulate a form of relief that would produce the end result with certainty, rather than having to come back and go through a debate as to what is needed.
Well, there's a question as to what is meant by Mauritian fishing vessels, and the statistics, the position can either be viewed on the basis it means Mauritian flagged vessels or Mauritian owned vessels or possibly both. I would have thought Mauritian-owned...
Mauritian-owned should do, and that's how it was being treated in the statistics. It wasn't because they'd been...
They were taking flag or owned.
They flag elsewhere. But if it was said that they couldn't be inshore fishermen, remember that's what they were doing. They were having licenses, even though they were flagged outside Mauritius because they were Mauritius/Chagosian owned. So it's to restore that...
They were getting it free, even though they were flagged in...
exactly, that was irrelevant.
Comoros and Madagascar. Yeah.
Could I... whilst
Can I just ask you one last question?
course.
Because I think we had the answer to this before.
Yes.
The document we now have, statement on implementation of the arbitral award, that's a document of today's date, is it?
I don't know, my lord. It was read out by my learned friend either yesterday or today, and I've assumed, having not seen it in the public domain, that it was written so that my learned friend could read it out to you.
Yeah. Well, he can clarify.
Yes.
As I understand it, it was his instructions.
Yeah.
The statement on the implementation of the UNCLOS arbitral award.
Well, yes, your lordship raised the question yesterday to Mr. Fleming.
It's a statement made today.
And it's a statement made today prompted by your lordship's question yesterday.
Thank you very much.
Well, Lord, what I was going to show you, when dealing with that point, before we had that statement, is could you at some time look back at the speaking note of Mr. Kovacs, which is dated the 28th of June.
Yes.
So the position of the British government as of the 28th of June, paragraph 14, Mauritius also demands that the MPA be rescinded. How outrageous of Mauritius. Before progress can be made on consultation on the future of the marine environment. And then this, the UK has no present intention to revoke the MPA and does not consider revocation to be a prerequisite for such consultation.
What were your questions?
Paragraph 14 of the speaking note from Mr.
Page
Kovacs.
4.
Yes, right.
So that's, my lord, why we say that we do need relief. Could I just give you one or 2 points on the fishermen themselves, because you've been read a mass of information by my learned friend, taking up his time yesterday. We went through Yaden 1, 2, 3, the same with Roberts, and we touched on Mr. Christoph Talbot. And Mr. Christoph Talbot was interviewed. So was Alan Talbot. One of the Talbots said to Miss Eden in the middle of 2009, in July, between the May meeting with the US representatives and before the consultation, and there's reference to it would be disastrous. If you read on in what Miss Eden records, volume 2, page 660, she then says he did not explain what he meant, but then talked about tourism. She doesn't record, I didn't ask him what he meant, because she knew very well what he meant. But the story continues. If I can give you the references. Mr. McManus, volume 2, page 677 to 8, paragraphs 24 to 25, says the Talbot family have been involved in fishing in buyout waters for many years. The crew of Talbot vessels were largely Chagosian. So that was the evidence that should have been put before the Secretary of State, or should have been put before the public. And then the whole sad story is brought to a conclusion in Mr. Dunn, his third witness statement at paragraph 79 to 89, volume 2, page 819.
Yep.
I'll just read you 3 lines at the end. Following the proclamation of the Chagos MPA in April 2010 and the cessation of all fishing in November 2010, the Talbot Fishing Company Limited and Me Fish Limited, those are the 2 companies, Alain Talbot and Christophe, were wound up and their fishing vessels scrapped.
Yep.
So it was disastrous. And when you look at Mr. Roberts talking about Mr. Talbot is criticised for not raising Mauritian and Chagosian fishing rights. That's paragraph 38 of his third witness statement at page 765 of volume 2. Now, I'm going to deal with the whole of Mr. Kovacs' evidence for much of yesterday in a couple of sentences. He spent some time trawling through the evidence to establish no improper purpose, and that there was no reason to take account of Mauritian claims to fish as of right. And we had hours of that, and we were taken through exactly the same material that was read out to the Divisional Court and read out in part at least to the Court of Appeal. On the no improper purpose, none of it deals with the cable because the cable has become inadmissible. On the second of the points, all of the evidence ignores our grounds of appeal. I know we still haven't got permission, but the whole point of our appeal is that there has been new evidence that should have been disclosed by the respondent, and evidence that comes out of the international award, which undermines the factual case upon which my learned friend relies.
I think we do have that.
My Lord, can I give you the paragraphs and one example? In our, it's, as I said before, it's Mr. Dunn, number 4, but paragraphs 22 to 62 of the appellant's case, and I need one correction as I was reading through. If you go paragraph 38 to 50 is probably a good example. There are many documents there referred to.
Yep.
But if I can...
What's the correction? Yep.
If you go to paragraph 49...
Yep, page 158.
Yes, my Lord. The theme that's being set out there is that there is a verbatim report.
Yes.
And at the foot of paragraph 49, there's reference to Mr. Silabuck.
Yes.
And it says the wrong name. It should be Mr. Boolel, B-O-O-L-E-L, and both of them are seen as recording in the presence of Mr. Roberts that there was an assertion of their fishing rights independent of sovereignty.
Right.
And that's just one of the many examples that undermines the evidence. So our grounds of appeal have not been touched, have not even been addressed. My Lord, could I think I can now leave the speaking note on fishing rights. On ground 1B...
You're into injury time very much, Mr.
You've probably had enough of me on 1B. On attribution, could I deal with two things? One is, first of all, on abuse, on improper purpose, materiality is the test as to whether or not it has an impact. But an important point of law to clarify is assume that there are other purposes, an environmental purpose, as well as the purpose to affect the claims for settlement by the Chagosians. Then you have mixed purpose. The Divisional Court at paragraph 78, for your note, didn't deal with it because it didn't come up. Right. So it's paragraph 78.
We have that.
And the case law is itself interesting. You've been given the copy of the Eclairs group case. The bit that you haven't been given is where the reference then goes, which is off to, my Lord, your Lordship's judgment in the FDA case. So could I just show you where you get to and then give you the document?
Just give us the reference.
That's all I'm going to do, my Lord. In divider 11, divider 12 is the Eclairs group case.
Yes, we've got that. Yeah.
And the last paragraph takes you to Lord Justice May, and then your reference to that, my Lord, in the FDA case. The FDA case we will provide for you. If you look at those paragraphs, you will see that if there is an irrelevant factor, an improper purpose, then normally that should be the end of it, if it's material. However...
It's only if one's satisfied, really sure, that it wouldn't have made any difference that one can interfere. That's the point.
That's the point. Well, if I said would, I'm back to my argument on would or should. That's just by speed. My Lord, I've tried to compress...
There's a lot of material both you and Mr. Kovacs have had to compress into your submissions. We quite understand that. As I said to Mr. Kovacs, it applies equally to you. In your written material, there will be a lot of stuff you haven't had a chance to refer to. That will obviously be taken into account.
It's all there. It's all relied on. Those are our submissions on behalf of Mr. Bancoult. Thank you for listening to us.
Thank you very much. Well, thank you to all three advocates who addressed us. As I say, there's a lot of material here, and you've had to cope with it in 2 days, and we're grateful to you for that. We're also very grateful for the written cases we've received and to those who've helped compile them. We will consider this matter and let you know our decision in due course. Thank you all very much indeed. The court's now adjourned.